Welcome to Advisory Opinions. Don't touch your iPhone. I know this is not Sarah. This is special guest David French, guest hosting for Sarah with perennial special guest of the special guest. I don't know how we're going to say it, but anyway, I'm David French, joined by David Lat. You've got the Davids today while Sarah is on vacation. We've got a great podcast. I've got to say, probably better than the last one, David, which included an extended discussion of post-trial motions. Not our most exciting moment, but one I was kind of strangely interested in because of my own practice. But we're going to be talking about the nation's first religious charter school. How does that work? We're going to be talking about the text history and tradition test involving the Second Amendment and some new cases, including a district court talking about a ruling on an assault weapons ban. We're going to talk about the richest partners in the United States of America. But first, David, let's start with a little bit of a Scotus grant here on a First Amendment issue that is interesting. Not earth-shattering, but interesting. So first, welcome, David. Thanks for coming back to Advisory Opinions. And second, fill us in on the new Scotus grant.
It's always a pleasure to be here. Thanks so much, David, for having me. I feel a little guilty here cheating on Sarah, who's my usual partner here, but I'm always delighted to be here. So yesterday, the Supreme Court, or actually, correction, Monday, the Supreme Court granted one new case. It is the case of Vidal v. Elster, Vidal being Kathy Vidal, who's the head of the U.S. Patent and Trademark Office. Elster is actually an attorney, but in this case, he is a would-be T-shirt hawker. He wants to sell T-shirts with the slogan on them, "Trump too small," referring, of course, to that infamous moment a number of years ago when Trump, at one of the presidential debates, got into that jousting with Marco Rubio about his Trump having small hands. And Elster, I think, wants to argue that Trump's policies make all of us smaller, make our nation smaller. And so he wants to hawk these T-shirts. But there is a provision of the trademark law that requires the refusal of registering a trademark when the mark references a person without their permission, essentially, to kind of sum it up. And there is, however, a First Amendment issue, because here Elster wants to make an argument against a public official, a former public official, a public figure, Donald Trump. And so the question that the court's going to tackle, or that is teed up, is whether the refusal to register this trademark under the relevant provision, 15 U.S.C. 1052C, violates the free speech clause of the First Amendment when the mark contains criticism of a government official or public figure.
Interesting case, and it's always these little First Amendment trademark type cases always end up with some pretty cruddy speech attached to them. We had a previous case dealing with a trademark regarding an Asian band that listeners might recall the name contained a racial slur, and one of the issues was, well, was that going to be something that could be protected or not protected? Here we have a crude joke, because I think people might remember the issue wasn't just whether Trump's hands were small. So that was one of the moments in 2016 that foreshadowed everything that was to follow. And so here we have Trump too small. And I've got to say, David, I was thinking through this, and the initial, here was my blink, and then I rethought my blink response. So my blink response was, okay, I get it. This sort of default idea that I own my name, that you can't trademark my name. If I saw a T-shirt that said Aquaman is bad, David French, like, that's not only is that completely wrong, but you're profiting off of my name. So don't I have some ownership? And my initial blink was, but what about, I mean, this is a former president of the United States. I mean, this is sort of core, you know, you don't want to say political speech necessarily because he's trying to sell something, but the commercial nature of it doesn't completely change also the political nature of it. So I don't know. It seems to me that a public figure of office holder carve out makes some sense. But then I started to do my internal line drawing. Okay. Is it only if you hold or held public office? But those aren't the only people who are worthy of critique or sort of satire or mockery or whatever in the public square. Where are you drawing the lines? How is it that you're going to end? You know, what's your sensible line as to when I'm going to actually own my name versus I'm too famous anymore to own my name? And the bright line distinction started to make a little bit more sense to me the more I thought about it. But this is a case I'm really open. I'm ready to read the papers. I'm ready to hear the oral argument. What's your first reaction to it?
I think I'm with you on this, David. I'm very torn on it. On the one hand, I'm super pro free speech. On the other hand, I do think it is a tricky line drawing issue here because there is the right of publicity. There is the right to protect your name and to profit from your own name and not to have other people profit from your name. And so I think this is a very tricky issue. The Biden administration actually did request cert in this case. The Federal Circuit said that the registration is okay, basically, saying that he should be allowed to register this because of his First Amendment rights. But the Solicitor General's office said that the Federal Circuit is wrong and it should not have struck down this federal statute. And so they are actually saying that it is okay. And one of the issues that the government is raising is whether or not this is a restriction on speech or whether or not it is a condition on a government benefit. So for those of us who are very pro free speech, we can maybe sleep a little bit better if we think of it the way the SG's office is thinking of it, saying, well, this isn't a restraint on speech, but if you're going to have the government benefit of a trademark, then you have to comply with this rule about not referencing some living person without their consent.
Yeah. And that does comfort me. There's not a prohibition on saying Trump too small. You can say Trump too small all you want. What this is dealing with is your ability to trademark the phrase, to have some commercial exclusivity attached to it, which does absolutely change it's the only thing that makes me have some pause about it. It's the only thing that makes me be torn. If this was any kind of prohibition on saying the words, of course that would be completely unconstitutional to restrict saying those words. Absolutely unconstitutional. Now here comes the government benefit, but it's an important government benefit, one that's established for a lot of good reasons. But yeah, so the more I think about the line drawing, the more convinced I am that there is some sensibility in the original rule. But at the same time, you are talking about a regulation that's relevant to what in any other circumstance would be considered kind of core political speech. So, yeah, I'm open.
Yeah, it's a tricky case, and I have a hard time predicting where the court will go on it. So you mentioned the one case that is part of this series of cases about the Asian American band, and then there was another case involving the prohibition on basically registering obscene trademarks, where I think somebody had a brand that wanted to spell out, well, it's FUCT. You see what that spells. And
Right.
the court said, no, you should be allowed to trademark that, basically, or that you can't refuse the registration on the grounds of obscenity. And so the last two cases have been sort of on the pro speech side, but this may be a little bit different. And it is interesting that the Solicitor General is weighing in favor of defending this statute.
Right, right. And there is an argument here that is distinct from the the case involving the band and case involving the FUCT, which, because this is a family podcast, we won't do what Sarah does and test the beeper. I think we had our live podcast at the University of Kentucky where I think the count was Sarah dropped about 19 F-bombs and our beeper caught 18 of the 19. Anyway, so I won't test it, but the obscene trademark, the racist trademark, or the racial slur trademark, both of those are a little bit different in that you can't, other than sort of a general offense to the public, in other words, sort of these words inflame people in general, there isn't sort of an individual injury aspect to this, where there's potentially sort of an individual injury aspect of this. If I'm a public figure, someone's profiting off of my name, image, likeness. Where are we on that? That's a little bit of a different, it's not necessarily a purely victimless crime, so to speak. But do we care about the quote unquote victim? And I'm using that word extremely loosely. Victim. Do we care about the victim in this context? Interesting case. One of those lower stakes Supreme Court cases that is nevertheless fascinating.
In some ways, I find these cases even more interesting. It doesn't necessarily have this political tinge or valence to it. And again, of course, I think whenever the former guy is involved, we just have to remember that we might kind of want to have these T-shirts, but we have to think about, well, what if the T-shirt or the trademark involves somebody we actually like? So we just kind of have to think about the rule for everybody, not just that guy.
Yeah, absolutely. All right, well, that's our brief SCOTUS update. There will be more. There will be much more. It's pretty stunning, David. It's June 7th, and we have so many more opinions to come in 3 weeks. And I mean, a little over 3 weeks. It's going to be a wild ride. Are you expecting just a giant dump right at the end?
Yeah, no,
well, what's your rank speculation on how this turns out?
So it's interesting. Earlier in the term, I was thinking that, maybe they're going to have to blow or get really close to their usual deadline. They like to be done by the end of June or July 4th, but they have been doing a little bit of catching up. So I think that they maybe will make their deadline. Earlier in the term, they were historically slow. I think the slowest they've been since the term started in October. Adam Feldman at Imperial Scotus has been tracking this. They've done a little catch up, so I think now they are kind of where they were last term. So they might finish up in time, but we will see. They may have to dismiss a couple of things, like Moore v. Harper, perhaps. So the independent state legislature theory case. So we will see what happens there. But no, it is going to be a busy month for SCOTUS watchers.
Yeah, I'm absolutely fascinated, not just by the outcome of some of these cases, but how this is all going to play out. Because as a journalist, I'm going to be not just podcasting, but writing about some of these major cases. And if they all just land at once, it's going to be a nightmarish few days. Great for the podcast audience, not so great for us. All right, so let's move on, David. That's our short SCOTUS update. Let's move on to a really interesting new development in the world of education and the Constitution. So a number of listeners, and I know a number of you saw this because you sent me messages about it, but a number of listeners have brought this to my attention. I've seen now a lot of news about it, and it is a decision in the state of Oklahoma to approve the nation's first religious charter school in the United States. And so here's a little bit of the facts. You had the Oklahoma Statewide Virtual Charter School Board approved by a 3-2 vote earlier this week the St. Isidore of Seville Catholic Virtual School to be run by the Roman Catholic Archdiocese of Oklahoma City and the Diocese of Tulsa, with religious teachings embedded throughout the curriculum. So this is a charter school that has been approved to be run, and it's a charter school that is religious that has now been approved as a charter school. Okay. Why is this important? Haven't we, some of you longtime Advisory Opinions listeners, you might be asking, why is this important? Because haven't we kind of gone over the availability of public funds for private religious education before? In other words, in the voucher context, there's now a number of cases that say if you establish a voucher program or something similar to a voucher program that allows parents to direct tuition dollars towards private schools, is now very clear, if you set up that system, which you can, it is now very clear that you cannot embed religious discrimination in that program. In other words, you cannot say to parents, you're going to be able to get a voucher for every kind of school except a religious school. There's going to be a religious non-discrimination requirement. And so you might be thinking, well, okay, doesn't that straight line apply to a charter school? After all, aren't charter schools run by private corporations, for example? Don't charter schools have widely varying philosophies? So why wouldn't you have a religious charter school? Doesn't that make sense? But there's a key distinction. And this is a distinction that I think is going to be very interesting, because when you think it through, you start to wonder, how can this work? So the key distinction is that charter schools have always been considered, sort of in the vernacular of the movement, as public schools. They're a unique kind of public school. They're a creation of state statute. They're funded by the state. Individuals go to them for free. There is not a tuition payment the way there is in a private school. I'll just use the language from the Oklahoma City Public School website. It says charter schools are innovative, non-sectarian public schools which provide educational choices tailored to the community needs and which provide greater accountability for results. Charter schools are open to all children, do not charge tuition, and do not have special entrance requirements. In other words, this is generally considered a public school. Now, to put an emphasis on that, there is a Fourth Circuit case that is currently before the Supreme Court of the United States called Peltier versus Charter Day School, in which Charter Day School was defending from legal challenge its dress code. And David, I am super happy you're here, so do not interpret anything that I say as any any disappointment at all that you're here. But I do have some regret that Sarah isn't here to hear me read part of the justification for this policy that exists. So the Fourth Circuit, this day school, created a dress code for its female students, and a mother objected because the female students had to wear skirts or skirts. It was more limiting in what they could do. A student writes in with an objection to the skirts requirement, and here is the response. The trustees, parents, and other community supporters were determined to preserve chivalry and respect young women and men in the school. For example, young men were told to hold the door open for the young ladies to carry an umbrella should it be needed. Ma'am and sir were to be the preferred forms of address. There was felt to be a need to restore and then preserve traditional regard for peers, and later elaborated that chivalry is a code of conduct where women are treated, they're regarded as a fragile vessel that men are supposed to take care of and honor. And I'm going to end this filibustering in a minute. Essentially, what the parent argues is this violates equal protection, 14th Amendment. This is a state school that is imposing a gendered code that lacks sufficient justification, violates equal protection. Fourth Circuit en banc says, you're right. You're right. This is a public school. It is not a private school. Therefore, it is subject to constitutional limitations and restrictions. And this is the leading case. It has been appealed to the Supreme Court. The Supreme Court has asked for the views of the Solicitor General. The Solicitor General agrees that this is a public school. We don't know what's going to happen to this case. But if this stands, if the Supreme Court affirms, then barring really radically meaningful distinctions between the Oklahoma situation and the North Carolina situation, Oklahoma will have approved a Catholic public school. David. So this is interesting. I know you've got thoughts. Fascinating case. What did you think as you saw this unfold?
So this would be a huge, huge development, as you note. And it is interesting here that two Republican officials in Oklahoma are going the opposite way on this.
Yes.
The Republican governor, Kevin Stitt, is in favor of the Catholic charter school, but the Attorney General, also a Republican, Gentner Drummond, who has joined lawsuits, for example, attacking various Biden administration policies, basically said that this is unconstitutional under the Oklahoma Constitution. And it's kind of funny that he has said that publicly because he's going to be the person who presumably has to defend this thing in court. And he has basically said it's unconstitutional. So it's going to be very, very interesting. In the Peltier case, which I guess we'll see whether the court grants, the Solicitor General, as you mentioned, has come out against it. But it's a tricky issue. The argument basically against the charter school is, look, when you have some entity that has been given this state function, you could get around all kinds of requirements if you somehow allow for this. Basically, to quote the SG's brief, a holding that CDS, Charter Day School, is not a state actor would allow states to evade constitutional constraints by delegating core governmental functions to private entities. And so I think that is the tricky part. On the one hand, we have this line of cases which has been growing stronger and stronger over the years, that if you have some kind of benefit, for instance, you can't deny it to a religious group or entity that is similarly situated to a private one. And I think we're going to talk about that a little more in just a sec. But on the other hand, there are various other provisions, including here a state constitutional one that may limit the ability to send money in the direction of religious entities. So this will be very, very interesting. We'll see how, first of all, how this Oklahoma litigation goes, or I'm sure it'll turn into litigation, and we'll see how whether the court agrees to hear that Fourth Circuit case. The Fourth Circuit, as you mentioned, went en banc. There were some vigorous dissents from Judge Quattlebaum and Judge Wilkinson, conservative judges on the Fourth Circuit. So it's possible that conservatives on the Supreme Court might side with the conservatives from the Fourth Circuit and grant this case.
Yeah, it really is. And it's worth diving a little bit more into some of the facts in the North Carolina case. So it's not all that exceptional from what charter schools are generally. It was a general educational program open to all students in the district. It received 95% of its funding from government sources. It's directly overseen by the North Carolina State Board of Education. The public charter schools are defined in the North Carolina laws as, quote, public schools. The charter is granted and revocable by the state. The charter requires compliance with the North Carolina State Constitution and the federal Constitution. Now, all of that should have, if you're hearing all of that, you're thinking, how is this a closed case? I mean, that's a public school. But on a day-to-day basis, it is run by a private corporation called Roger Bacon Academy, Inc. It's a privately owned corporation. A lot of charter schools are run by privately owned corporations. And part of the purpose of allowing these privately owned corporations is to not be like the typical public school. In other words, one of the whole reasons why you have the charter system is so that they are not bound by or limited or constrained by a lot of the regulations that apply to conventional public schools, which has made them quite controversial within the public school establishment. There is an interesting degree of backlash especially in progressive school reform circles against charter schools, which are seen as something outside of, different from, interlopers in the public school system. So it is not, in fact, just a complete lay down hand that these are public schools because of the private ownership, or the private management, and because of the very intentional way in which they've been carved out from the public school system. And so the dissent, I think, accurately points out that you have different people running it than you do have in the public school system writ large. But here's two things, okay? So David, number one, here's easy, and number two, here's hard. So here's the easy part. It seems to me that if you have a charter school that is deemed a state actor, there is no way on earth you can have a Catholic public charter school or a Jewish public charter school or any faith at all, because it then becomes the religious entity is a state entity. And that, I don't see how that can constitutionally work. Let's leave aside the state constitution for a minute. On a federal basis, I do not see how that can constitutionally work. Am I missing something?
No, I don't think you are. I think that is really the tricky part here, and that's the easy part, or
that's the easy. I'm just doing a sanity check. You can't have a public Catholic school. Now, here's the harder question. Let's say it's not a public school. It's a private school, deemed a private school. But unlike the private schools we have seen in in Maine, for example, in multiple cases involving charter vouchers being sent to a private school, the funding mechanism here is very different. This is not a voucher-based funding mechanism. This is just pure, straight public funding transfers to a religious school that members of the public can go to for free. That is a different order of funding, of public funding of a religious institution, than we have seen from other programs. And this is where the new post-Lemon world gets really interesting. So if it's a state actor, no way this is constitutional. If it's not a state actor, it's still funded substantially differently from a normal private school. This is a free school that anyone can go to. It's direct funding by the state. Post-Lemon, David, I'm not sure where that comes out.
It is interesting, though, because you could argue doesn't all kind of wash out the same way, in the sense that if you had a lot of students who were going there and taking government money in the form of vouchers or some other funding scheme, is that really that different? At the end of the day, you have government money that is winding up in the coffers of some religious or religiously tinged entity, and that's been held acceptable. You mentioned the Maine case from last term, Carson v. Macon. And so on the one hand, you see the challenge with having a religious charter school, but on the other hand, why can't you do directly what you can already do kind of indirectly? The other thing I would kind of mention or kind of flag is I do wonder whether, on the one hand, you might think, well, if you're a strong proponent of religious freedom, well, maybe this is great. But on the other hand, it is starting to blur the line between the state and religious entities. And sometimes maybe it's better to have a cleaner line. We have had also a line of cases about the ability of religious organizations to organize their own affairs free of secular interference. And, if you blur the line for one purpose, are you blurring it for another?
That's the next step. That's the next question in my mind, because it's not just funding. If you look at charter schools more broadly, they're a heavily regulated entity. They're a very heavily regulated entity because they've always been perceived as public schools. They've been advertised as public schools. This is what a charter school is. It is a unique kind of public school. So even beyond the funding, you're talking about a level of entanglement that do you want if you're a religious entity? Are we at the point where you're merging church and state? The authority of the state is intruding on the autonomy of the church. And so are we getting too entangled in the sense that by availing myself of the charter school program, I get the benefits of being able to have free tuition where people can come in from all over the community? Great. That's fantastic. But I also have heavy state regulation, which starts to, as you were saying, blur these lines. And David, I think it's very interesting to me because this echoes, and this was I'm actually writing about for my newsletter, kind of the conflict you see on the right now between liberty and authority. So especially in the education context, sort of the traditional conservative education reform effort has always been, or for the last 20 or 30 years, has been about more liberty. In other words, more school choice, more freedom for students to speak, academic freedom for professors, more liberty, less state control. But we've seen in the last 2, 3, 4 years greater exertion of authority over schooling on the part of the right. So the passage of the anti-CRT laws, the Florida, HB 1557 restricting instruction on sexuality and gender. You've seen much more effort to sort of exert the state authority, the library book restrictions, to kind of control much more what students see. And I see this commissioning of a Catholic public charter school as part of that authority prong more than the liberty prong, if that makes sense, because it is a public school by the Oklahoma City School District's own definition. So I see it more on that authority prong than the liberty prong, although the language of religious liberty was used with that level of state control. It's hard for me to see it as truly religious liberty and much more state authority manifesting itself through a religious entity is where I am on it now. I'm not sure, what do you see as the best sort of argument against me on this? Where are you on this?
Well, are you in favor or against St. Isidore of Seville Virtual Charter School?
Oh, I would have voted against it. I would have voted against having that as a charter school. Now, if you have a voucher program in Oklahoma and they want to use it for St. Isidore, more power to you, right? It's not if St. Isidore is a normal Catholic school, which, by the way, my oldest daughter is going to a Catholic school for high school here in Nashville. Huge supporter of religious education. I am. Long supporter of vouchers. So if St. Isidore was a truly private school, and this was a voucher setup where the money was sort of given to the parents or guided by the parents, I'm all in. But if it's a public charter school, I'm pretty sure I'm all out on that because it's just too entangling, even putting aside the funding. That's kind of where I am.
I think at the risk of not having enough exciting conflict here, I think I probably come down with you the same way. And I'm also a big fan of religious education. I went to a Catholic high school run by the Jesuits. I think there are many values and virtues to religious education, but if you are going to have a public charter school, I think having it with religious content, affiliation, instruction, what have you, can present some serious difficulties. And I do think it's the entanglement issue. I think for people who do support religious freedom, there is sort of be careful what you wish for quality to this. And here's an example. You mentioned, of course, how schools are very heavily regulated. Public schools, charter schools are very heavily regulated. So there have been, or there was a Supreme Court case about the right of a religious organization to dismiss a teacher if the teacher, say, had views that were different from the religious organization or expressed views or engaged in conduct that was different. I'm forgetting the exact particulars, but the ability of the religious organization to make these personnel decisions that reflect its religious beliefs was upheld by the court. Well, what if you have one of these religious charter schools and they want to get rid of a teacher, but there are all sorts of rules and regulations about when and under what circumstances a public school can get rid of a teacher. So it gets really, really messy.
Yeah, it does. It gets very messy. And the way I've articulated it is, over the last few generations, our jurisprudence, the combination of establishment clause jurisprudence and free exercise clause jurisprudence, have kind of have created a system in which there is absolutely a disestablishment. In other words, the state cannot wrap its arms around a particular church and use state authority to advance a particular church. But at the same time, in exchange for sort of this loss of the level of church state authority that churches used to enjoy, say in Europe, for example, they get a degree of autonomy from the state that churches never enjoyed in previous regimes in Western civilization. So this ministerial exemption that you're talking about, this sort of absolute freedom to hire and fire ministerial employees without regard to state or federal non-discrimination statutes. That's a pretty big deal. That's a pretty big deal. And are we in a position where a public charter school can enjoy that same autonomy if it's religious, but not if it's not religious? Again, this gets very, very, very dicey. And in a way, going back to my authority versus liberty construct, it really does implicate this concern that I have that if you begin to erode and tear away at some of these separations between church and state, that the entanglement, historically speaking, between church and state has not been good for either entity, the church or the state. And I think it's no accident that the United States of America has a far healthier religious practice than exists in the states of Western and Eastern Europe, which pioneered and perfected entanglement of church and state. So it strikes me that on that authority versus liberty axis, the more you're exerting the authority at the expense of the liberty, the more you're going to end up harming perhaps many of the same institutions you're seeking to empower.
One last point I would just make is also, how do we go about deciding which religions can have charter schools? So I think
Right.
Catholic organizations have been very active in education. There are a lot of big Catholic schools. People say, okay, fine. But what about a less sort of numerically popular religion? What if I wanted to have an Islamic charter school or a Jewish charter school or a Protestant charter school or what have you? I know that sometimes you and Sarah talk about, well, what about the Satanists? Because they always show up. So no one's going to have maybe a
Yeah,
Satanist. They always show up. This is why we can't have nice things. So maybe not a
Yes.
Satanist charter school, but whatever principle you apply to defend Saint Isidore, presumably it would apply to other religions as well. So that
Right.
I think is also something to think about.
Yeah, absolutely. Absolutely. Well, should we move on from, we've hit Trump, religion, and guns. We're moving on to guns, which we're like a walking MAGA hat here. It's like God, guns, and Trump. That could be the name of the podcast, God, Guns, and Trump. So really interesting, and Advisory Opinions listeners will know that this is sort of an old riff for you guys, but text history and tradition as the test that is the test applied to firearms regulation post Bruin is now working its way through the federal courts. We've talked about it in the context of the Fifth Circuit, and how the Fifth Circuit struck down a limitation on firearms ownership by people subject to domestic violence restraining orders. Sarah and I don't know, I think we might have competed with each other in the level to which we were appalled by that particular decision. But at the same time, understanding that the text history and tradition test creates challenges. And there was, and one of the first questions I had under text history and tradition was, what about assault weapons bans? Because no one disputes that the AR-15 did not exist in the 18th century. It did not exist in the mid-19th century when the 14th Amendment was passed. The AR-15, semi-automatic rifles more generally, much more recent invention than, but at the same time, nobody who's credible argues that all the Second Amendment does is protect the kinds of weapons, the firearms that were in existence at the time. That the first way to find out that somebody is not steeped in Second Amendment jurisprudence is when they try to make that argument. So we know that it's not the Second Amendment is not limited to the weapons that existed when the Second Amendment was ratified, or when the 14th Amendment, which ultimately incorporated the Second Amendment, was ratified. We know that. We also know from previous precedent that not all weapons are protected by the Second Amendment. Heller makes that quite clear. So what is under text, history, and tradition? Pretty sure machine guns are not. Pretty sure machine guns are not. Pretty sure a 6-shooter revolver is, or a pump-action shotgun is. But what about a semi-automatic rifle with a pretty hefty magazine? Is that protected under text, history, and tradition analysis? And this Washington court was very interesting because what it essentially said is that no, under text, history, and tradition, the assault weapons ban actually fits a pattern. So here's what the district court upholds Washington district court upholds a assault weapons ban and basically makes this argument. The argument is, in fact, the history and tradition of the United States shows that the development of new weapons has always been accompanied by regulation of new weapons as soon as those new weapons prove to be unusually dangerous. So it's not what the court does is not go and look for text, history, and tradition regulating semi-automatic rifles. What it does do, it goes to look at text, history, and tradition on regulating new weapons that prove to be dangerous. And here's the court quoting an expert opinion. An early example of these regulations concerned the Bowie knife. Now, David, I did not expect a Bowie knife discussion. Concerned the Bowie knife, originally defined as a single-edged straight blade between 9 and 10 inches long and 1.5 inches wide. In the early 19th century, the Bowie knife gained notoriety as a fighting knife after it was supposedly used in the Vidalia Sandbar fight, a violent brawl that occurred in central Louisiana. Shortly afterwards, many Southerners began carrying the knife in public because it offered a better chance to stop an assailant than the more cumbersome guns of the era, which were unreliable and inaccurate. This is the single-shot musket pistol. They are also popular in fights and duels over the single-shot pistols. Responding to the growing prevalence and danger posed by Bowie knives, states quickly enacted laws regulating them. And this goes on to talk about the laws regulating. Also talks about laws regulating trap guns, which is a gun rigged to fire. If somebody comes into a certain place, they're not allowed to go into. And then goes into the regulation of machine guns and Tommy guns during the Prohibition era with a pattern that says, new weapon, proves dangerous, subject to regulation. Very interesting use of text, history, and tradition. And it also shows the malleability of the standard. I'm super curious what you think about this.
So Gabe Malore had a good Twitter thread about this, and he points out that what is interesting here with this approach as a Bruin alternative is it's not focusing on the time period of the ratification of the Second Amendment or of the time period when the 14th Amendment was ratified. Those are typically regarded as the relevant time periods for Second Amendment analysis, but it sort of reframes the issue. And Judge Bryan, the Washington district court judge in this case, Hartford v. Ferguson, reframes the issue as you described in this other way of, well, maybe we're not going to look at it at a weapon-specific level, but more at a level of a pattern of weapon emerges, is used by law-abiding people, then is used by criminals and is found to be dangerous, and then it's regulated. And I will confess, I think the Second Amendment, I try to be somebody who doesn't let my priors and my policy preferences affect my legal analysis, but Second Amendment is one of those areas where I think it's a little bit harder than usual to separate them. And personally, I'm not really a gun person. This is sort of an ongoing disagreement I have with my husband, Zach, who is a big fan of guns, and over my sort of grumbling, has some guns in this house. They're in a safe. They're, kept away. But we moved out to the suburbs, but I'm still sort of like an effete New Yorker at heart. Like, guns, scary. I don't like guns. And so I've always been, and again, I probably am letting my legal analysis be affected by my priors, but I kind of lean towards Justice Stevens' opinion in Heller. And I am now, I have to admit, somewhat sympathetic to this project of reframing the historical inquiry away from a weapon by weapon analysis, because as you mentioned, nobody's going to say, well, only muskets, or I don't know anything about guns. So only whatever was allowed at the founding is allowed. Muskets, or I don't know what they had back then. The weapon by weapon analysis, it should really be more of a holistic analysis in terms of patterns and trends. And so I'm actually kind of sympathetic to this project, but I actually agree with Gabe Malore that I think that if this goes up to the Supreme Court, Justice Thomas will not be so sympathetic.
Oh, I completely agree that Justice Thomas will not be sympathetic. I'm much more interested in Roberts and Kavanaugh.
Yes. And remember that Justice Kavanaugh, I believe, in Bruin had that concurrence where he basically, it was a classic Kavanaugh concurrence, going along with the conservative result, but saying, hey, here are some future issues that I've not made up my mind on, or maybe I've made up my mind on in the quote unquote liberal way, if you think about his Dobbs concurrence. But anyway, it's very interesting. And we could the trend in recent decades, Heller, McDonald, has been to go in favor of or pro the Second Amendment, but at a certain point it may hit a wall. And all these recent cases which present somewhat unsympathetic propositions. So, for example, you mentioned Rahimi, the Fifth Circuit case involving letting people under orders of domestic violence have guns, and then bump stocks, also out of the Fifth Circuit. Who really likes bump stocks, which were involved in the horrific Las Vegas massacres? So, you're now you may start to bump up against resistance.
Yeah, so that brings me to some cases that you sent to me when we were kind of doing our pre-show prep, involving, felon in possession. Felon in possession, which would, on the one hand, seems like an extremely unsympathetic person to approach the court. But what is the felony? What is the felony? So I think it's pretty clear. It's hard for me to imagine a case in which a court is going to say, if my felony was armed robbery, then I have a right to a gun. Under any possible notion of sort of responsible law-abiding citizen, a convicted armed robber is not that. But what if it is? What if it is something different? What if it is, say, you have to take a real life example? The issue wasn't you're an armed robber. The issue was you made a false statement to obtain food stamps years and years and years ago. Does that mean that you shouldn't have the ability to own a gun to defend yourself? What if it's something between a false statement to get a food stamps is pretty much the very definition of a nonviolent crime? What if it's getting more where you weren't actually violent, but you're in a dangerous business? You were convicted of sale of a controlled substance. What then? Does that forfeit your rights to self-defense under the Second Amendment? And courts are coming out in different places. And from your non-gun standpoint, what are your thoughts on some of these felon in possession analyses?
I tend to lean in favor of the courts and the judges that have upheld these restrictions. So the cases you alluded to, a week or two ago, we had the Eighth Circuit uphold one of these statutes where the underlying felony was a drug offense. And Judge Colleton, who's a George W. Bush appointee, wrote an opinion joined by two other Republican appointees, basically upholding the provision as applied to the defendant in that case. And as Judge Colleton noted in his opinion, Heller did say, to quote the famous language from Heller, that nothing in Heller, quote, should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons, close quote. So that was the Jackson case out of the Eighth Circuit. But then you mentioned the food stamp fraud felony, and that is the more recent case of Range v. Garland out of the Third Circuit, where the Third Circuit actually went en banc and went the other way as the original three-judge panel. And there they said that Mr. Range, who had committed the food stamp fraud, did not forfeit his Second Amendment rights, that he was within the group of, quote unquote, the people who enjoy Second Amendment rights. And then engaging in the Bruin analysis found that in this particular case, he's actually, again, to quote from Judge Hardiman's opinion, because the government did not carry its burden of showing that our nation's history and tradition of firearm regulation support disarming Range, Mr. Food Stamp fraud, we will reverse and remand, close quote. So that was the Range case, and there were some vigorous dissents, including a very interesting dissent by Judge Krause, Cheryl Krause, who's an Obama appointee, former Kennedy clerk, and she goes through an extremely exhaustive historical analysis defending felon in possession prohibitions when it comes to firearms. So this is going to be a super interesting issue, and I could see either the Washington case or the Third Circuit case coming to the Supreme Court in some way, or other cases out of the Fifth Circuit or other cases presenting these issues. So after a long period of not so much activity on the Second Amendment, then we had some activity, Heller, McDonald, Bruin. I think now, who knows, maybe we'll see one of these cases, I don't know, every term, every other term. I think we're in for a lot.
Yeah, I would agree with you completely, because it strikes me that this is not a situation where the Supreme Court can really sort of say, well, we're going to let this case law mature for a while. Like the gap between Heller and Bruin was a long gap, and things matured quite a bit. As I've said before, they matured enough to where the jurisprudence was shaving and got his driver's license. Like it was really maturing, overdue for some Supreme Court intervention. I don't see how they can let this just continue to percolate, because you're going to have different circuits with different provisions regarding felon in possession, different circuits with different provisions regarding domestic violence. You're going to have different circuits, almost certainly different circuits with different rulings under text, history, and tradition regarding assault weapons. That kaleidoscope of different rulings is going to have to be resolved by the Supreme Court. And I got to say, David, here's my prediction. My prediction is that text, history, and tradition is going to Second Amendment advocates are going to end up unhappy with the test. They're going to end up is unhappy with this test. And the reason why they're going to end up unhappy with this test is that the history and tradition is so much messier than sort of the top line understanding that a lot of people had going into discussing American firearm regulation. And because it is so much messier, it is malleable. And therefore, text, history, and tradition is actually going to end up being less protective in some ways than strict scrutiny would have been. And people might end up, gun rights advocates might end up 10 years from now less pleased with text, history, and tradition than they would have been with conventional levels of scrutiny. Could be.
I think I'm going to push back on you on that. I think I'm going to go the other way. I think that the so-called means end scrutiny, which was the old test, the tiers of scrutiny, what have you, I think that was very malleable, because you would look at the means that was being employed, the nature of the restriction, and then you would look at the public interest on the other side. And that was very malleable. That's a classic critique of just the tiers of scrutiny more generally. It's kind of like, well, the outcome is whatever the judge thinks it is. And I think that text, history, and tradition, so far at least, has been wielded or applied in ways that Second Amendment supporters or advocates should like. And so even though both standards have a degree of malleability, I think that Second Amendment fans, super fans of whom I'm not one, will end up happier with the new test. And I think partly they'll end up happier because the Supreme Court has the last word. And I think the Supreme Court is probably more pro Second Amendment than either A, the lower federal courts, and B, the American public. And I think that you're also right that we're going to see a lot more of these Supreme Court cases, not just because you're going to have this patchwork quilt of regulations and federal and state laws being struck down here and upheld there, but also as the epidemic of horrific gun violence continues to spread throughout this country. I feel like it just gets worse and worse. You can't expect the branches to just stand idly by while this happens.
Right. So, well, I agree with you that text history and tradition is more protective than, say, intermediate scrutiny. With, I think, no question. The question I have is it more protective of Second Amendment rights than strict scrutiny? Or another word, maybe another way of saying it is it more understandably and rationally protective of Second Amendment rights than strict scrutiny? So strict scrutiny is where a government regulation is going to fall unless it advances a compelling governmental interest through least restrictive means. And that's, what we've called strict in theory, fatal in fact. But in fact, there are cases that do survive strict scrutiny. And my assessment and my thought of it was that you would have, under a strict scrutiny regime, a regime that was quite broadly protective of both the kinds of weapons you could own and the rights of law-abiding citizens to own them, but much more subject to limitation in situations of extreme danger, or what's seen as extreme danger, such as someone who's been subject to a domestic violence restraining order, for example. That would be a classic example of how strict scrutiny would apply. There's a compelling governmental interest in keeping the gun out of the hands of people who commit domestic abuse, limiting the application of the regulation to people who've actually been adjudicated as guilty of domestic abuse or in an imminent threat of inflicting domestic abuse. That's a classic strict scrutiny kind of formulation that would meet that test. Whereas with text history and tradition, there wasn't even a category really of domestic violence in years past. And so you end up with something that is, in the Fifth Circuit analysis, is tied to text history and tradition, but in many ways is an utterly irrational kind of ruling that absolutely would collapse sort of public support for gun rights in that context. Very difficult sort of to sustain over the long term. But also deeply contestable. I went back, I read the case, and you end up saying, I'm not sure how they get to text history and tradition specifically protects the domestic abuser in this case. It's quite arguable. And so that's my issue, is text history and tradition is so much less certain and so much more, in many ways, subject to judicially influenced sort of preference than strict scrutiny. Not than intermediate scrutiny, but than strict scrutiny. And I think my prediction is you'll see that in Kavanaugh and Roberts, not in Thomas. but you'll see it in Kavanaugh and Roberts. But I could be completely wrong about that text history and tradition, ultimately the Supreme Court ends up being every bit as, if not more protective than strict scrutiny. That could be the outcome, but I'm a little bit dubious given the Kavanaugh concurrence and what we know about Roberts.
Well, what we had before Bruin, though, was not really strict scrutiny, though, right? It was, you had the lower courts developing this sort of two-step analysis, which Justice Thomas said was one step too many, basically. I do think that one significant thing about the Bruin/text history tradition analysis is I do think it has shifted the burden a little bit, because I think post-Bruin, it's very clear that the government now bears the burden of showing why, once you've established this person as part of the people who enjoy Second Amendment rights, the government bears the burden of showing why this person or member of the people is not entitled to them. And so I think to that extent, this new Bruin framework is more protective of gun rights.
Yeah, no, I think that's 100% correct. I think the reason why I highlight strict scrutiny is because if text, history, and tradition wasn't the test, gun rights advocates wanted strict scrutiny. They were united that intermediate scrutiny was too lax. Like that was my position as well. Intermediate scrutiny, just it's whatever the judge wants. I mean, we've talked about it before. Rational basis, the government wins. Strict scrutiny, the plaintiff usually wins. Intermediate scrutiny, the judge wins. It's what the judge wants, and I thought that was unsustainable. But the question then was, well, what should the test be? And in my view, the argument, if intermediate scrutiny wasn't the test, it was going to be between strict scrutiny or this text, history, and tradition formulation. And I fully and freely admit to being text, history, and tradition curious. I have just found it to be more of a mess than I thought it would be. More of a mess that's going to require more immediate Supreme Court intervention than perhaps applying more conventional and understandable layer levels of scrutiny or strict scrutiny would have been.
Well, in an example of how messy this is, the Third Circuit in the Range case was emphasizing the narrowness of its opinion. And when you read Judge Hardiman's opinion, it almost sounds like one of those ticket good for this right only sort of opinions. But then I've been reading some media commentary on it, and some media commentators have saying, oh, this court just held that non-violent felonies are exempted from felon in possession firearms restrictions. And I don't think that's actually what the Third Circuit held. I think that is overreading it. But what the Third Circuit did hold was, well, this particular guy with this particular nonviolent felony still enjoys Second Amendment rights. But now, even in the Third Circuit, you're going to have, I think, more litigation, because I don't think this cleared things up. I think it is very, very messy. One interesting thing that was floated by Judge Krause in her dissent was, well, why couldn't, in this case, then, the court just have said, issued a declaratory judgment, or basically a declaration of rights, saying that this particular guy going forward prospectively from this point in time onward gets the right to have a gun, but we're not going to say that the gun restriction on him after he became officially a felon was sort of void from the start, or void ab initio. And so that was sort of an interesting alternative, although even under Judge Krause's framework, you still would have had a lot of litigation, because then you're going to have all these one-off felons who want to have guns saying, well, what about my situation? So either way, you're going to have this is a great, for lawyers who practice in the Second Amendment area, you're going to be very busy. This is great. This is a permanent employment act for you guys.
Yeah, it really is a full. And so what are we going to have? We're going to have a litigation about gun rights in every nonviolent felony. I mean, it is just incredibly messy, just so messy. Well, we're already a little over time, but I wanted to get to something that you've been covering, and it's not really something that we've covered so much on Advisory Opinions, but I think it is interesting, and it's actually something that used to really focus my mind when I was in law school and I was considering my legal career, and that is, how profitable is big law these days? What are the big law firms that are the most profitable firms? How much money can you make as a big law partner? I find all of that interesting, and it's really been kind of a hole in our coverage, but you're on it, David. You're on it.
Yes, I covered this at my Substack newsletter, Original Jurisdiction, based on the annual rankings put out by the American Lawyer, the AmLaw 100, and also the AmLaw 200 rankings. And the short answer to your question is, how much money can these partners make? A lot. The profits per equity partner at the top firm for fiscal year 2021 were $7.5 million at Kirkland and Ellis, which was number 2 for a while, second only to Wachtell Lipton, which last year had $7.3 million in profits per partner. Full disclosure, I worked at Wachtell a long, long time ago. Wachtell, for many years, was the champ in profits per partner, but Wachtell is a very heavily mergers and acquisitions, M&A, transactional law focused firm. And 2021, after two incredible years in 2020 and 2021 for deal after two incredible years, the two prior years for deal work, 2022 was I'm sorry, the statistics were for 2022, and 2022 was not a great year for transactional work. And so Kirkland, which has a more sort of balanced practice, I would say, overtook Wachtell for the first time, I think, in something like 2 decades. But it's not just these two firms. The 20th ranked firm in profits per partner, Proskauer Rose, their profits per partner in 2022 were 3.7 million. So 3.7 million, it's not 7.5 million, but it's still significant. And one thing I should also mention, just for people who aren't as in the weeds of law firm economics, law firms generally do not retain much capital. They have the capital contributions or the so-called buy-in of partners. When you become a law firm partner, you invest or you are asked to put in some money. But generally, they pay out pretty much most or if not all of what they earn. So when you hear a 7.5 or 3.7, generally the average or median partner at these firms is often taking home that much.
Mm-hmm. Right. And it's, of course, not evenly distributed across the partnership. You'll have one partner, it's at 25 million. You'll have another partner. I mean, that might be high, but maybe. You'll have another partner at 2.5 or 3 million. And now the interesting thing about this is I remember there's this sort of sense in the practice of law that goes like this. You work for 7 years or however long the partner track is. And then you enter an entirely sort of new category of life when you hit a partner. You leave behind the associate life, you hit a new category of life, and you do, in fact, get a big pay bump when you become a partner. But your life actually doesn't really change that much other than what that money can buy for you. You're still working really, really hard. I think that's one thing that is, I think, important for people who are walking into big law. They need to know is there are giant financial rewards that are there. And you're not suffering, quite frankly, as an associate either. But there isn't a commensurate necessarily lifestyle change that goes along with that transition from associate to partner. And that was a sobering thing for me to see when I was a law firm associate.
No, it's so true. I would say that if you turn back the clock much farther, there was this notion of, oh, once you become a partner, you do get more of a life of leisure. Not exactly leisure, but things do let up and maybe you can play golf a little more or what have you. But today in big law, partners are very much working partners. And in some ways, many of them work harder than the associates because even if their billable hour requirements in terms of what they bill to clients might be lower, they have to spend A, lots of time on client development, and B, lots of time on firm administration. And so it is not unusual for a partner at one of these firms to work, not bill, but work 2,500, 3,000 hours when you count the administration and the client development. That is not unusual. So yeah, you're taking home millions of dollars. You may not be seeing your kids that much.
Yeah. I have seen law firm partners who are able to maintain those tight connections with their family, even though they're working these hours, and they have to really work at it. They have to put together systems and use a lot of their money to hire help for things so that all of their time with the family really is time with the family versus sort of the household maintenance and everything that most of the rest of us do. But I've also seen the opposite, David. I've seen that, when I was working in a Manhattan firm, a lot of the partners, they had an apartment in the city and they had what they called the country house or whatever, which was their house in the suburbs. And the family was there full time. And they were there in the apartment in the city quite a bit. And so they were just quite literally spending half, 2/3 time, not even living with their family.
That still happens.
Right.
Yeah. And, just one funny, note, and again, I know we're over, I kind of have been toying with this idea for a story, but kind of the dirty secret a lot of these two big law partner families is they have more than one nanny. I feel like before, the idea of having two or more people to help run your household was this sort of Hollywood celebrity thing, like, oh, whatever, Russell and Kimora Lee Simmons, they had a nanny for each child, or whatever, Jay-Z and Beyonce or something like that. This is now a thing that is done routinely by couples where you have two big law partners, or a big law partner and a GC or CLO, general counsel or chief legal officer of an in-house company. This is becoming increasingly common, but people don't like to talk about it because it just sounds so privileged to have two or more full-time employees to look after your kids and run your household. But this is how people make it work. And when you're making $7 million or $3 million a year, or maybe $3 million a piece or something like that, you can make it work.
Yeah. Yeah, you can afford to do that. And that's how they use their resources, their huge resources, to make their family life more sustainable. But it is difficult.
Yeah. You can't outsource the love your kids part.
Yeah, exactly. All right. Well, the time flew by.
Yes,
I
indeed.
appreciate it. And I'm so glad you joined us. And also, please, folks, if you don't subscribe to Original Jurisdiction, if you've not checked it out, you must. Really, truly, Original Jurisdiction, David's Substack is indispensable. It's fantastic. And it's not just analysis. You do a lot of original reporting. I mean, you've been absolutely, as we've discussed on this podcast before, you've been on top of the law school free speech controversies. This Original Jurisdiction is where you're going to get the first and best reporting on a lot of these law school controversies we've talked about. So please check out Original Jurisdiction. And of course, please like, subscribe, whatever, review positively, advisory opinions. I really appreciate your reviews. We really appreciate your comments at thedispatch.com. Thanks for listening. And next week, Sarah, the host, will be back.